Hey there, I'm Jason Whitely in the WFAA newsroom. We're coming on here with some breaking news this morning. About 30 minutes ago, the U.S. Supreme Court justices just released an opinion or a ruling. I'll get the exact wording on this in just a moment here, but it's significant about the Texas abortion law. And as we go here, Nick, I'm still on. I can still hear you, Nick, if you could turn that off. Thank you, sir. I want to make sure we lay this out here. This is a significant decision from the U.S. Supreme Court about 30 minutes ago on the Texas abortion law. The Supreme Court ruled essentially two things here. It's a mixed verdict, but ruled that the abortion providers in the state of Texas can continue to challenge in court the fetal heartbeat law that passed, the SB8 that passed. But there was a split ruling on this, as we mentioned. In a 5-4 ruling, the court will not allow the lawsuits to go forward against state court clerks. The abortion providers had sued state court clerks in order to stop this law from taking effect. So a split ruling here this morning. Let's get to one of our guests this morning, Brian Owsley. He's the associate professor of law at UNT in Dallas. Brian, can you hear me this morning?
I can, yes.
First takeaway from this. I have a number of questions on it. I'm sure our viewers do too, but first takeaway on this. What do you think?
First takeaway on this is it's not a good decision if you care about Roe versus Wade. This is a decision that basically, in many ways, refuses to uphold the court's precedent in Roe versus Wade, and that doesn't bode well. Most notably for Dobbs versus Jackson Women's Health, which is the other abortion decision that the Supreme Court heard argument earlier this month on.
And it doesn't bode well for the Roe versus Wade ruling from 72 or 73, simply because, I don't know if I mentioned, SB8 can stand right now in Texas. The Supreme Court did not strike down SB8. So 39 days after Texas went to D.C. on November the 1st to go ask for an expedited hearing, the justices came back and they said, you know what, SB8 is going to stand. We're going to allow these the prohibition on abortions beyond 6 weeks or so whenever a fetal heartbeat is detected. That seems significant. You mentioned Roe v. Wade. That was one of my questions. Does this continue to chip away at that landmark decision?
Yes, it does. I think chip away. We might be seeing the end of Roe versus Wade in the coming months with the 1-2 punch of this decision and Dobbs. I would say that as I understand it, what the decision does vis-a-vis Roe and SB8 is it doesn't issue a stay. In other words, the state of Texas is still allowed to enforce SB8 while abortion providers are allowed to challenge it in court. In other words, many times, for example, let's talk about Dobbs versus Jackson Women's Health. There, the court stayed in light of Roe versus Wade. The trial court and the appellate court upheld because of Roe versus Wade. Here, the Supreme Court and the lower courts have not stayed the implementation of SB8. So in other words, if you are someone in the state of Texas who is seeking an abortion, you are stuck under the rules established in SB8.
And you've mentioned Dobbs versus Jackson Women's Health a couple of times. For our viewers who might not know that, that's the Mississippi case that essentially was heard right after the Texas case was last month. And that one's the one asking for 15 weeks. Go ahead, Brian.
Exactly. That's a 15-week decision or law. And the court heard argument about a month after it heard argument on the one for Texas and SB8. The court had decided sometime in the spring to hear argument on Dobbs. So that wasn't any revelation. The court took up the appeal in SB8 as an emergency matter. And so on some level, we've been waiting quite a while for this decision because of the emergency nature of it. we now have that decision going forward, and I expect we'll get a decision regarding Dobbs, this term, and quite possibly we'll no longer have Roe versus Wade as good law.
Well, lay this out for our viewers here too. So for now, the SB8 remains the law of the land in Texas. Women cannot get an abortion beyond 6 weeks. That was not stayed by the court, as you mentioned. So what happens next in this? Because the justices did say by an 8-1 ruling that these abortion providers who are suing over this can continue their cases. What happens next with these cases then?
So the providers will go back and they will find the appropriate individuals to sue and go forward with cases challenging Roe versus Wade. This was, I think, for some background, SB8 was a very distinct statute in the sense of what it did was try to prevent the law from being challenged in federal court. And I think that's why you see so many of the justices giving pause. For example, Justice Kavanaugh, during oral argument regarding SB8, was very concerned about the approach that the state of Texas had taken in enacting the law, and noted that potentially legislatures in maybe blue states could take a similar approach to limit gun rights and target gun owners. And so maybe the state of New York or the state of California could use this approach. And so I think on some level, the state of Texas was thumbing its nose at sort of federal courts and federal judiciary power. And that's never going to be a great recipe for success at the Supreme Court. They're going to guard their ability to basically review, consistent with Marbury versus Madison, matters before the court. And so, and challenges regarding the federal Constitution. So that's, I think, what's driving sort of the 8-1 decision. But as we've been talking about, there's the abortion component that is also a large part of this decision.
Yeah, and just to reiterate what you were saying there, the thing that made this law so unique and so different is the fact that the state did not enforce SB8. Enforcement of SB8 was left up to individuals anywhere. There were people a man in Illinois, a man in Arkansas, both who sued over SB8 simply because the law allowed them to do that. I asked you what happens next here too. People who might be watching this are also saying, hey, I thought I just saw a headline though yesterday from a state court ruling that the enforcement mechanism violates the state constitution. So lay out kind of what's happening here, because there are two parallel cases kind of underway right now. One on the federal level, which the Supreme Court offered some guidance on today, and then one on the state level here too, Brian.
Exactly. So the matter before the Supreme Court that was just decided today concerned litigation in federal court, starting in federal district court at the trial level. There was the suit by the providers in federal court, and there was also a suit in federal district court by the United States seeking to enforce Roe versus Wade and attacking this approach. And so that will go back. The matter of the providers will go back to federal court, and they can start to litigate if they can find proper defendants.
Yeah, if they can find someone. If they can find someone to sue, you were saying. Go ahead, Brian.
No, they have to. If they can't sue the clerk of the courts, they're going to have to figure out who they can sue. Possibly state judges. There was a concurrence by, I think it was Chief Justice Roberts, that indicated he thought, not only he thought that the clerk of the court could be sued, but he also thought that the Attorney General for the state of Texas could be sued as well. So that will sort of be sorted out, but that litigation challenging SB8 will go forward in federal court. As you noted, there is a parallel track in state court, and that is proceeding, as you noted, with a decision yesterday by one judge. Again, I think judges in Texas state court are also probably a little wary of this approach to basically to design a system where litigation is foreclosed for anyone to challenge the nature of the statute. And also, as you noted, at least early on, I don't know if there's been any recent filings, but there was a provider out of San Antonio who wrote an op-ed and said, I basically violated this law. I provided an abortion for a woman who was outside of the 6-week limit. And that individual was sued by the gentleman from Arkansas, who is a disbarred attorney, who acknowledged he didn't really have a stake in the abortion fight. He just wanted money. And there was another gentleman outside of Texas who sued as well, who I think characterized themselves as someone who was in favor of a woman's right to abortion access. And so he was just sort of trying to challenge it to move things along. And then, so part of, I think, the state judges might be wary of is that anyone and everyone's just coming in, suing everywhere, anywhere. It's pretty loosey-goosey on some level, and that could give pause to a number of state judges who just think it's not well designed and maybe problematic, putting aside the question of Roe versus Wade, but for procedural reasons pursuant to Texas state law.
Let me just reset for our viewers who might be watching us now. We're speaking to Brian Owsley. He's the Associate Professor of Law at UNT Dallas. We're on here digitally because the U.S. Supreme Court about 45 minutes ago ruled that abortion providers in the state of Texas, they can challenge the Texas law, SB8, that bans abortions after a fetal heartbeat is detected about 6 weeks in. But the Supreme Court left that law in place while these legal challenges continue. We just got a tweet also here from Whole Women's Health. This is one of the plaintiffs involved. And the tweet says, the takeaway from SCOTUS, we won on very narrow grounds. Our lawsuit can continue against the Health Department, Medical Board, Nursing Board, and Pharmacy Board. We'd hoped for a statewide injunction, but no clear path to it. Rest assured, we will not stop fighting. We aren't entirely sure what's going to happen. It's disappointing SB8 is so blatantly cruel and unconstitutional, and the court has decided not to grant us relief. While we hold out hope for the rest of our lawsuit, the court still failed us today. So what you hear from that, from Whole Women's Health, is essentially that mixed verdict, the split ruling, because the justices, as you know, we want to reiterate here, did say that the law can stand while abortion providers continue to challenge this in court, but they will not let, the justices in a 5-4 decision said, you can find somebody else to sue essentially here, because you cannot sue the court clerks in all 254 counties across the state. Brian, I want to come back to you for one last thought on this. As we look forward, as people are digesting this news and as both sides are trying to figure out exactly what the entire ruling says, because it's a pretty thick one here, what should we be watching for next?
Well, a couple of things. One, we've talked about the parallel track of these two decisions, or two, state court and federal court litigation. So, as you heard from the tweet from Jackson Women's Health, they're going back to court. As they characterized it, as a very, very narrow victory for them. The victory for them is they get the right to go back to court and proceed with their challenge to SB8. The problem is, as they noted, SB8 is still the law of Texas now, and so it is impacting women's right to have access to abortion services. And so they probably want to get in court as quickly as possible and challenge it as quickly as possible. I doubt that they're going to be able to go back and get injunctive relief in light of the decision by the Supreme Court. So they're going to have to go and attack on the merits and get it done as quickly as possible. In light of Dobbs, there's a lot of flux. So I think the court can uphold the Mississippi statute in Dobbs and still strike this one down, but we'll have to see what happens in Dobbs. And I say that because 15 weeks is considerably longer than 6 weeks, obviously. And so there is some wiggle room there, but if you are someone who supports a woman's right to abortion, this is not a great decision. And there is concern about Dobbs on the horizon.
And just to reiterate again, you keep mentioning Dobbs. That's the Mississippi case, but you think you just mentioned something there that I want to expand on just a moment in our final seconds here too. You said that the court might be willing to let the Mississippi case stand, which would ban abortions after 15 weeks, and then strike down the Texas case. How might that happen?
So, again, it's always dangerous to read tea leaves, but
right.
The court in the oral argument of Dobbs if you start counting justices, seems to be inclined to uphold Dobbs. Now, before the court was not the expressed this question of whether or not Roe versus Wade should be overturned. But in order to uphold Dobbs on some level, you have to overturn Roe versus Wade. But if the statute in Mississippi is upheld, then basically the limit is down to 15 weeks in the state of Mississippi. And so you could see potentially, depending on the language in any decision by Dobbs, where 15 weeks might be an acceptable point for the court, whereas 6 weeks, the language in the decision may not support something as limited as 6 weeks. My concern is that the court is either in Dobbs or in subsequent decisions going to basically just say there is no right to an abortion. And we heard, for example, Justice Kavanaugh basically arguing for neutrality, i.e. Can't be either pro or anti-abortion. But that there is that gap between the 15 and 6, and that's how possibly you could have that happen.
But Professor Owsley, if the 15 weeks, if the Mississippi case stands and the 15 weeks becomes the law of the land, there's a trigger law in the state of Texas that would make it happen here immediately as well too, where the state of Texas would adopt that. But if that happens, the time limit for Roe versus Wade, the 26 weeks, that would be reduced down to 15 weeks. Could someone say that Roe versus Wade no longer exists because the time limit has changed?
Well, so I think what would happen with any upholding of the Mississippi statute is, yes, Roe versus Wade has sort of talks about first trimester, and then I think right. Casey versus Planned Parenthood talks about 24 weeks and stuff like that. The problem in upholding the Mississippi statute would be essentially that the court was jettisoning the approach of viability, okay, which was what I think the core holding of Roe versus Wade, especially after Casey, existed. In other words, a woman would have a right to have an abortion before the fetus was viable. Once it was viable, then states had rights or the ability to protect rights on behalf of the fetus, and could basically enact laws that would limit abortions after viability. But at 15 weeks, it's accepted that fetus is not viable. And so in order for the Mississippi statute to be upheld, you would essentially have to, the court would have to jettison the viability approach, which is really the core of Roe versus Wade now.
Yeah, makes sense. Thanks for clarifying that. This is certainly a Supreme Court term to be watching. The term is up in the summer, so there's a lot that we should be watching for between now and then, and when the term is up, which is obviously when a lot of the decisions are handed down too. That's Brian Owsley. He's the Associate Professor of Law at UNT Dallas. Brian, we'll be calling you back, I'm sure, as we try to put all the pieces together on this, but thanks for the time this morning.
Thank you. You all have a good day.
Appreciate it. And just to reiterate to our viewers exactly what happened here about 52 minutes ago, the U.S. Supreme Court ruled that abortion providers, they can legally challenge SB8. But it's important here what they said. They said they're going to let SB8 stand. It remains the law of the land in Texas. You cannot get an abortion beyond 6 weeks, but the abortion providers still can pursue lawsuits on this. But until they find a defendant and go forward in a court and try to get this overturned, SB8 remains the law of the land in Texas. We're still putting some other eyes and ears and trying to make sure we understand this thing, putting eyes and ears on this case and this decision that came down within the last hour. We're going to have an update on WFAA midday in about an hour or so. I hope you can join us then. Take care.